The situation that Britain addresses today, or rather the Labour government addresses today, about the ICC arrest warrant for Netanyahu, let alone Gallant, and Putin, of course, encapsulates a profound diplomatic and ethical conundrum, juxtaposing Britain's legal obligations under the International Criminal Court framework against the realpolitik of international coordination, international relations. The ICC arrest warrant for Netanyahu and for Putin effectively rule out our participation in hosting any peace process, either for Putin and Ukraine or for Netanyahu and Palestine. And that I think is an unfortunate position. The UK's stated commitment to upholding its legal obligations, as expressed by Keir Starmer, or by Keir Starmer's spokesperson this morning, suggests that the arrest of the Israeli Prime Minister could theoretically proceed if he entered British territory. However, this theoretical compliance is laden with political complexities that mirror those surrounding the Russian President Vladimir Putin's ICC arrest warrant earlier this year. Putin's spokesperson has made it quite clear that the arrest of Putin would be an act of war. The ICC issued these arrests for Netanyahu for former Defence Minister Yoav Gallant, citing war crimes and crimes against humanity, including starvation as a method of warfare. And these accusations arise from Israel's military actions in Gaza, which, while aimed at neutralising Hamas, the group responsible for the October the 7th terrorist atrocity, have inflicted immense civilians' suffering. It's a matter of a group punishment for individual crimes, and that must be wrong. And there are shades of genocide covering it. The UK's stance sharply contrasts with Germany's position, which was expressed by Stefan Hebseit, who says that there's reluctance to execute the warrants because of Germany's unique relationship with Israel, rooted in its sense of historical responsibility for the Holocaust. Similarly, in the US, a non-signatory to the ICC, the warrant was dismissed outright, with President Joe Biden calling it outrageous. Biden's rejection underscores a stark difference in international approaches to ICC rulings, and the US. The US's exclusion from the ICC enables it to shield allies from prosecution, reflecting geopolitical favoritism that undermines the court's credibility. So if everybody doesn't agree with what the court says, what's the point of the court saying it? Keir Starmer's government has attempted to straddle legal objection and diplomatic nuance by reiterating the importance of dialogue with Israel, describing it as a key partner. Yet the ambiguity of the statements by the Home Secretary Yvette Cooper, who deflected questions about the ICC warrant's execution, exemplifies the complex path that the UK has chosen to walk. Historically, similar warrants against figures like Putin have been met with unequivocal support by Britain, revealing an inconsistency in the UK's application of international law, a critique levelled, quite rightly, by Palestinian advocates. Netanyahu's case shares parallels with Putin's ICC warrant over war crimes in Ukraine. Both leaders preside over current military conflicts with significant civilian casualties and alleged breaches of international law. In both cases, the civilian casualties seem to have been part of the intention rather than an accidental byproduct. The global response diverges markedly, however. Western nations broadly endorse the ICC move against Putin, aligning with their support for Ukraine. Conversely, Israel's status as a key Western ally and its historical ties complicate similar endorsement for Netanyahu's warrant. This discrepancy highlights an uncomfortable truth. The enforcement of international law often bends under the weight of global alliance. And that makes such international law pointless, doesn't it? Critics like Tayyip Ali of the International Centre for Justice for Palestinians argues that the ICC's decision smashed Israel's decades-long impunity to pieces. But the ICC's lack of enforcement mechanisms leaves compliance to individual member states, a vulnerability Netanyahu's government has exploited by dismissing the court as anti-Semitic. The UK's adherence to the ICC warrant would not only strain its relationship with Israel, but also face significant domestic challenges. Priti Patel, representing opposition to the ICC actions, warns against moral equivalence between Israel and Hamas. This view echoes US sentiments and reflects a broader Western discomfort with prosecuting allies for war crimes. Yet, as Labour MP Emily Thornberry has said, the UK's ratification of the Rome Statute binds it legally, regardless of political implications. The warrants complicate peace negotiations. Holding both Netanyahu and Hamas leader Mohammed Deif accountable might appear even-handed, but it risks entrenching antagonisms. Critics warn that targeting a sitting prime minister, a leader integral to any peace talks, hinders any diplomatic efforts. This tension is further exacerbated by the ICC's symbolic limitations. While the warrants represent a moral victory for accountability, they lack the enforcement power to achieve tangible justice. The UK's response to Netanyahu's warrant will set a precedent for far-reaching implications. If Britain chooses enforcement, it risks alienating a vital ally and further complicating Middle East diplomacy. If it abstains, it undermines the ICC and international law's universality. By contrast, figures like Biden and potentially Trump may leverage this episode to highlight divisions within the West over international legal standards. In doing so, they amplify the perception of selective justice, leaving international law precariously exposed to political manoeuvring.